when a historic college sorority in Laramie, Wyoming, admitted its first transgender member. 6 sisters didn't just protest. They launched a high-profile federal lawsuit that turned a quiet, snow-swept Wyoming campus into a national legal battleground. This wasn't just a dispute over who gets to live in a house. It was a fierce legal showdown over the very definition of a single word in a contract, and whether a federal judge has the power to tell a private organization how to interpret its own rules. In today's video, we are breaking down the fascinating and highly controversial case of Westenbroek v. Kappa Kappa Gamma. It's a story about bylaws, the First Amendment, and the limits of the court system in the state of Wyoming. The story begins in 2023 at the University of Wyoming, home to a chapter of the Kappa Kappa Gamma sorority. Kappa Kappa Gamma is one of the oldest women's sororities in the country, with deep traditions and strict internal bylaws. That year, the local chapter inducted a new member, Artemis Langford. Artemis is a transgender woman for the national leadership of Kappa Kappa Gamma. This was in line with their modern interpretation of membership. But for 6 specific sisters in the Laramie chapter, it was a breach of everything they had signed up for. These 6 women, led by Cheyenne Westenbroek, decided to take drastic action. They filed a massive federal lawsuit in the U.S. District Court for the District of Wyoming. Their legal argument was fundamentally rooted in contract law. When these women rushed the sorority and paid their dues, they signed binding agreements. They argued that the sorority's internal contract and historical bylaws define members strictly as women. By inducting a transgender woman, the plaintiffs claim the national organization had breached its own contract, violating the promise of a single-sex housing space in an exclusive sisterhood. They weren't just asking for their dues back, they were asking a federal judge to step in, void Langford's membership, and legally force the sorority to define the word woman based on biological sex at birth. The lawsuit immediately caught fire in the national media. It became a proxy war for broader cultural debates. But inside the courtroom of federal Judge Alan Johnson in Cheyenne, Wyoming, the cultural noise didn't matter. What mattered was the law. Kappa Kappa Gamma's defense attorneys fought back, and their strategy was brilliant. They didn't engage in a biological or philosophical debate about gender. Instead, they invoked one of the most powerful constitutional shields available to private groups, the First Amendment right of expressive association. The defense argued that Kappa Kappa Gamma is a private, voluntary organization, and under the United States Constitution, private organizations have the absolute right to determine their own members, hit criteria, and interpret their own bylaws without the government or a federal judge breathing down their necks. They pointed out that the sorority's National Council, the highest governing body of the organization, held the contractually valid authority to interpret the bylaws, and that council had previously issued guidance defining women to include individuals who identify as women. Essentially, the defense said, "Your Honor, you can't tell us what our own rules mean. We are a private club, and we have decided what woman means for the purposes of our club." This brings us to the legal twist. The plaintiffs were asking Judge Johnson to look at the Kappa Kappa Gamma bylaws, look at the word woman, and legally define it for them. Judge Johnson refused. In a decisive ruling, Judge Johnson dismissed the lawsuit. And he didn't just dismiss it, he dismissed it with prejudice, meaning the plaintiffs could not simply fix their complaint and refile it in his court. In his written opinion, Judge Johnson made it clear that the federal court's job is not to micromanage the internal affairs of private organizations. He wrote, "The University of Wyoming chapter is a private, voluntary organization. Having considered the issues presented, the court will not interfere with Kappa Kappa Gamma's interpretation of its own bylaws." The judge ruled that because the National Council had the authority to interpret the bylaws, and they had interpreted them to include transgender women, no breach of contract had occurred. The court essentially said that if you join a private club, you agree to let the club's leadership interpret the club's rules. If you don't like how they interpret them, your remedy is to leave the club, not to ask a federal judge to rewrite the dictionary for you. The plaintiffs didn't give up immediately. They launched an appeal to the 10th Circuit Court of Appeals. but the appellate court echoed Judge Johnson's sentiments, upholding the dismissal. The Westenbroek case is a landmark moment in Wyoming legal history, not just because of the controversial subject matter, but because of what it reaffirms about American law. It serves as a powerful reminder of the strength of the First Amendment's protection of private association. Whether it's a sorority, a private golf club, or a religious organization, the courts are incredibly reluctant to step in and tell a private group what they can and cannot admit. In Laramie, Wyoming, the law ultimately decided that Kappa Kappa Gamma, and only Kappa Kappa Gamma, gets to decide who is a Kappa. Let me know in the comments. Do you agree with the judge's ruling that private clubs should have total control over their bylaws? Thank you for watching. If you found this breakdown of Wyoming law fascinating, hit the like button and subscribe for more deep dives into the most unique legal cases from the Equality State.